Good evening. I'd like to call the Plainville Planning and Zoning Commission's February 10th, 2026 meeting to order. First item on the agenda is roll call. Will is an excused absence. Will actually had a stroke and is just home from the hospital. So he will not be with us for a couple of meetings. Yeah. So if anybody wants to send him cards, texts, calls to let him know that we're thinking of him. I've talked to him and he's doing okay. And I know Deb is out of state, so I know she's not here, but I didn't hear anything from Gwen. So other than that, we have a quorum. Item number 2 is public hearings. We don't have any items. Item 3, unfinished business, PZ01/26, number 1, site plan, Tilcon Incorporated, 0 Loon Lake Road, 475 New Britain Avenue, proposed installation of permanent stone processing equipment for quarry zone. If you can just turn the mics on, whichever ones you're going to use, please. And then just state your names and address for the record.
Carolina Cavalcante, President for Tilcon, 300 Woodford Avenue.
Chris Costello, Environmental Land Manager, Tilcon, 300 Woodford Avenue.
Good evening, Attorney William Migalski, 73 East Main Street for Tilcon Inc. So we're here tonight. We presented substantially all the application, and I believe we're here to address the issue of the intervener.
Yes.
Are they planning on putting anything on or no? Any testimony, any evidence?
Yes. Georgia, it appears, is interested in offering testimony.
Pardon?
Yes. The interveners in the audience has indicated that she'd like to offer testimony.
Okay.
Come on up.
God bless you. Oh, you will?
If you could just state your name and address for the record, please.
Certainly. Georgia Bedell, 28 Pequot Road. Thank you, Madam Chair and members of the Commission. Before I begin, let me put my glasses on. For clarity and completeness of the administrative record, I note that I submitted a written section of 22A-19 supplemental filing and corrections of the record on Wednesday, February 4th, in advance of tonight's meeting. I hope that the commissioners received that material at the time so there was adequate opportunity for review prior to tonight. Before turning to the deficiencies, I want to clarify one point under section 22A-19. As the environmental intervener, I am not required to provide technical proof or act as a scientific expert. The statute requires only that I raise colorable claims of conduct reasonably likely to cause unreasonable pollution or impairment of public trust resources. Once such deficiencies are identified in the record, the Commission may not authorize conduct unless it is substantial evidence showing no unreasonable impairment will occur or no feasible and prudent alternatives exist. I also want to clarify one point regarding Tilcon's inland wetland permit. With respect to the inland wetland and watercourse approval, staff's own review reflects that the mapping conditions imposed by the Commission is not clearly documented as having been fulfilled. While the revised wetland impact assessment plan has been submitted by the applicant, the record does not contain a confirmed staff sign-off or other documentation verifying that the stipulation conditions were satisfied. As a result, the administrative record remains incomplete and requires clarification before any further action is taken. The Commission has before them a written section of 22A-19, supplemental filing, identifying unresolved material deficiencies, including, first, the absence of a lawful scope and intensity determination. While quarrying exists historically, the North Quarry saw minimal activity for decades, followed by significant operational escalation beginning in 2024. The record does not analyze that change. For nearby residents, this escalation represents a clear, lived change in daily conditions. Second, reliance on an unsettled and improperly amended plan of the POCD not lawfully adopted under Section 8-23. This creates uncertainty for both this application and long-term land use decisions. Third, the absence of professional planning review. The town does not currently have a town planner. The town engineer is serving as both roles, as the acting basis while maintaining engineering responsibilities. This application involves permanent industrial equipment with long-term land use impacts. It is reasonable to question whether the depth of planning analysis typically required can occur when one role is stretched across so many functions. Fourth, reliance on an outdated traffic study premised on assumption that no longer reflects current or planned development conditions. The traffic study expressly assumes that there are no planned or pending planned development districts within the study area. However, the record reflects proposed development, Tomaso residential units, as well as additional commercial development, including a car wash and a fast food establishment. When traffic analyses are based on assumptions that no longer align with documented development activities, their conclusion cannot reliably reflect real-world conditions experienced by the residents. Fifth, the absence of any determination regarding new source review air permits. In addition, the town has been repeatedly asked to establish air and water testing protocols associated with this operation. As of the submission, there is no definitive adopted plans for such testing. Without established monitoring, potential impacts cannot be meaningfully evaluated or verified over time. Sixth, incomplete analysis of dust, water, and downstream discharge impacts relied on generalized summaries rather than enforceable site-specific standards. These are public trust resources residents depend on daily and that cannot easily be restored once repaired. And seventh, a screening level endangered species review that deep cautioned is insufficient for approval. That caution reflects the limits of preliminary review where irreversible decisions may result. Before I conclude, I ask the Commission to direct its attention to the monitor. These images you're seeing reflects existing site conditions, not assumptions, including blast dust visible over 1.8 miles away, uncovered trucks without documented dust suppression times from the time it went into the truck until it gets dropped off, trucks idling over uncovered catch basins, and berms intended to screen quarry operations from public review. Sorry, I didn't see it wasn't up yet.
Where are they?
Dan. Do you want to go up
Need
and
some
help them?
help?
Yeah.
Is it, are you looking at the D drive? I mean, I've got the disc, I mean, it's showing this file folder of the pictures. I
Right.
just don't know where to open it to.
And it just double click it.
Just open?
Can you make it bigger, please? Sorry about that. The images you're seeing reflects existing site conditions, not assumptions, including blast dust visible over 1.8 miles away.
Click the middle square. Town engineer.
Thank you. Uncovered trucks without documented dust suppression timing from the time they're loaded until it's dropped off. Trucks idling over uncovered catch basins and berms intended to screen quarry operations from public view. These berms are described as features that may eventually vegetate. However, as of today, they remain exposed, and the record provides no basis for concluding that effective screening will occur within any defined time frame. Finally, I note that while you serve as members of the Planning and Zoning Commission, you are also residents of Plainville. The impacts discussed affects the same roads, the same air, the same water, and landscape shared by all of us. With so many material inconsistencies and unresolved questions in this application, I believe it would be premature to move the application forward. Asking for clarity and completeness of an application is not obstruction. It is a stewardship of the community we all call home. I am comfortable resting on this statement. My position is fully set forth in the written submission, and I respectfully have no further comment. I rely on the existing record that I've presented to you. Thank you.
Thank you. Yep. Plus one for John.
Got some extras if the public wants them. Okay, good evening. William Galsky again. Tonight, I would encourage you to reject the verified pleading for the intervention of Ms. Georgia Bedell because it lacks specific allegations of harm, it draws conclusions without providing reasoning or cause, and it admittedly references issues beyond the scope of this commission. We're here for a very limited purpose tonight, and that's to look at the placement of equipment and plant on the ground. That's it. The statute by which this pleading arises contains very specific language. In subsection A1, there must be conduct which is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources. So those are the things that we're looking at: air, water, or other natural resources. The words reasonably likely. This requires something more than just conjecture or imagination, something more than just potential, as stated by her in her correspondence of February 4th. It also involves reasonableness, something factual, something definitive that can be similarly recognized, interpreted by all the commission members and not have 7 different or 6 differing interpretations. Focus on the wording, reasonably likely. It's not just likely, but supported by reasonable evidence, something tangible, something you can measure. This operation has been in existence for over 100 years. It's very highly regulated. We'll share with you in a few minutes the numerous regulating authorities. It's probably the most broadly regulated business in town, maybe along with the airport. You're not required to become environmental experts on various activities. That's up to the other agencies. Just like you're not charged with delving into the refrigeration units at Americold or the air conditioners at the public library. And in considering reasonableness, you can consider that this is an ongoing operation. It's not a new endeavor. It's been a successful contributing member of the community and its economy for generations. There is no history of environmental abuse. It has come before you numerous times for site plan modifications over the past 50 years as the need has arisen to replace plant. The modern era for these plants is over 50 years, going back to the Clean Water Act of the early 1970s. The petition before you is akin to the operator of the airport coming in for new landing lights, but having its whole underlying operations questioned and critiqued. Your charge is simple. It's an administrative one involving a review of your regulations in black and white to determine if Tilcon's proposal complies, the placement of the plant on the ground. This is not a legislative action like a zone change for which you're entitled to discretion and could rely on unspecific goals in the POCD. The POCD is irrelevant here. The specificity of your regulations is all those of your concern. As the intervener does rightfully mention, those regulations are admittedly not numerous. And why not? I proffer to you that is because there are so many other reviewing agencies that fulfill the oversight, and because that oversight has been working for decades. Tilcon has been coming here before you every year for over 50 years with its annual review plan. And over those 50 years, there's been no history to support a claim that its operation is reasonably likely to cause unreasonable pollution. A review of the verified complaint reviews that is just a restatement of the statute, contains no specifics, contains no expert analysis, and seeks to push the burden of proof onto the commission. It also contains misstatements and misapplication to the statute. For example, a proper reviewing authority need not consider feasible and prudent alternatives unless there's first been a finding that the activity is reasonably likely to be causing unreasonable pollution, impairment, or destruction. A review of the January 27th written submission reveals that it fails to identify even one specific fact that the proposed plant and equipment will reasonably likely to cause unreasonable polluting. What it does acknowledge is the fact that there are a multitude of other regulating agencies. I've given you a handout there. The first 8 pages are an expert for the Supreme Court case of Nazardo versus State Traffic Commission. It's an easy case, and in that case, an intervener sought to raise environmental issues before the State Traffic Commission, which had no regulations on the environment. In short, the court ruled that the environmental issues must be raised before the agency which has some jurisdiction over them. And I would suggest that you do not have jurisdiction over these issues. And why? Anybody? Because you don't have any regulations concerning them, as evidenced by the numerous agencies that do, which you'll see in a few moments. You can read what's there in about 3 minutes. I've highlighted a few of the relevant passages. There are a few entertaining ones even in there. The court states that the inland wetland agencies are not, quote unquote, little environmental agencies. And as the Chief Justice Peters coyfully writes, the invocation of the act is not, quote, an open sesame, unquote, for standing to raise environmental claims. Another analogy, you regulate marijuana retailers where they can go, but you don't regulate the goings-on inside the store. You regulate where of the airports, but you don't regulate the how of how they operate, or the hours, or the flight paths. We have the FAA for that. For as complex as the operation of the airport is, our regulations, I've given you a copy of them there on page 9, it's just 3/4 of a page long. And it's not novel to have an agency to have a proposed development go through multi-agency review. The Plainville and Wetlands Commission, anything with motor vehicles goes through DMV, any food service or restaurants under the Department of Health. With your cannabis regulations, you require that a license from the Department of Consumer Protection is a prerequisite to opening. The regulation and that regulation on page 10 of the handout specifically mentions other agencies' approvals that are needed. We've had rare occasions with site plans on Route 10, which is Farmington Avenue, East Street, or Route 72, New Britain Avenue, East Main Street, West Main Street, which would obtain your approval and then get denied by DOT and have to come back for a revision. And just last month, we had Laurel Court had to come back for a revision to a site plan because it didn't conform with the building code fire protection. The market to obtain this crushing equipment is small. There are not 29 flavors to choose from or infinite models or options like when buying a car. The plant and equipment available have to be able to meet federal standards. At the initial meeting, we were told that the improvements today's plant has over older versions. Common sense should tell you the technology does not worsen. The interveners produced nothing about any of the proposed plant to suggest that it would unreasonably likely to have the effect of unreasonably polluting, impairing, or destroying the trust in the air, water, or other natural resources. And that's all we're focusing on is that plant. We're not focusing on the operation of the ongoing operations up there. That's already in place, and it's already regulated. We're focusing on the plant that's going to be planted on the site plan. Finally, on the last page, for procedural reasons, I requested in your motion to approve this application that you state the application complies with the applicable regulations over which the commission has jurisdiction. The corollary to that would be if you find that this project does not comply, then specifically cite the regulation which it does not meet, and there are no such regulations. Carolina.
So as Attorney Gauski mentioned, and you actually pointed out in the last meeting, the environmental aspects related to noise, dust, and water related to quarrying are currently regulated by federal and state agency. And as a commission, you rely on those regulatory bodies to monitor and enforce limits. I will pass around, Chris, maybe you can hand it to them. What you'll see in front of you is a list of all the federal and state agencies that currently oversee all aspects of our operation, including any and all of our possible environmental impact areas. I'm happy to answer any questions related to what I've presented, or any other question the commission has.
Does the environmental intervener have a copy of this? Do you have one that she can have?
She can have one, yes.
Thank you.
If I could ask one question related to this. Not doubting the accuracy of this information at all, but is it your contention then that because these regulatory agencies exist and regulate your activities, the town is preempted, or this body is preempted from acting?
Essentially, yes, because you don't have any regulations to govern these. Look in your zoning regulations. There's nothing that talks about limits for dust or noise. And those are the factors that come under the environmental statute. Okay, it's not open to a wide open thing. It's dust and dust noise that affects water. Okay? And yes, because you don't have any regulations, in effect, we're not saying they're without a remedy. they're just not in the right room. The right room is either any one of those other agencies that are listed on there. What's the most comprehensive one, the federal mines?
Yeah, one of the top one that we list is the Mine Safety and Health Administration. So that it oversees all aspects of our operation. And it actually conducts 2 unannounced visits. Every surface mine has to have 2 visits per year. So they come on site, they look at our paperwork, they walk through all the details of the plant. If there's issues with safety, they can, as Josh mentioned last time, they will do testing on noise. They will do testing, part of the hearing program. They will do testing on dust. One thing I would like to add, last year there were 2 hazards complaints submitted by the neighbors for our operation, and MSHA responded to that and was on site and investigated the hazard complaints. There were, in total, they visit our Plainville North operation 11 days, and they were in our south operation for 12 days. In the north one, there were 2 citations. They were both documentary and procedural findings. None of them were related to the actual nature of the complaint, which was blasting, dust, noise. All of that came out clear. And this is public information on MSHA that can be researched, and all the results. You can look up any mine in the country. It will show the inspections. Another thing I will say, one of the ways we're measured is citation per inspection day. So our rate for citation per inspection day in Plainville North is 0.18. That is 4 times lower than the national average. All of Tilcon is 0.31. Again, lower than the national average. We are very proud of how we operate. A lot of times the MSHA agents congratulate us for how we take care of our plant and how we put safety first.
So the permanent equipment that you're looking to install, replacing the temporary equipment that is there
Yep.
in existence now. In the hierarchy of equipment that is available on the market today, that is absolute best practice.
Yeah.
Where does this equipment that's proposed to replace the temporary fall in that hierarchy?
It's state of the art. It's the top. The brand is Metso. It's part of a company called Melot, and it's the top provider in the country. We did have considerations of other equipment, and we decided against it because we wanted the best possible one on site.
And so just to reiterate, when it comes to all of the other regulatory bodies looking at operations on site which supersede our regulatory ability as a planning and zoning commission, they're comfortable, obviously, if that's state-of-the-art equipment in terms of dust control, et cetera, all of those categories that we've been talking about and that were raised as concerns by the environmental intervenor relevant to the operation of the equipment itself that's looking to be replaced.
Yes. So when I came in the first meeting and we presented the improvements that we were going to be able to implement, again, our goal is to improve what we currently have, and we want the best in that site. We are, and I mentioned this with our team, our parent company has the most stringent and aggressive targets, and they're public targets in terms of environmental protection and CO2 reduction. So what we are putting into this site is to meet those levels. We want to do everything we can. I appreciate the input of the neighbors and the things they have brought up, and that has actually already helped us improve what we are doing. We have looked at other technology that we can implement now on our current operations to continue to improve.
Do any other commissioners have any questions?
I know all the testing is public record. Do you currently have all those public records listed on a website for the quarry that could be easily found so we don't have to go hunting for, through MSHA, DEEP? It's obviously a lot of work. You already have all those testing.
Yeah.
Would it be possible to do something like that?
Yes, it's not on the website currently, but that is possible. I do have, do you want to give me the MSHA one? No. So I can pass this around. It talks about the rates I mentioned and the, yeah.
I trust all your information. The big concern is just better visibility for
yeah.
the community.
Yeah.
And I think that'll help and probably go a long way, especially farther down the line when you do any other changes.
Yeah. The other thing that we were asked by the town council to share was the data around dust. And I just want to make sure I find the right part and I tell you. So on August 21st, 2025 and September 5th, 2025, we shared the dust testing results conducted by MSHA and third-party labs with the Director of Health, Susan Lotchak, from the South Central Health District, which covers Plainville. This was at the request of the Plainville Town Council and Representative Martinez. All the sampling levels were below the threshold. And as I said, that MSHA testing was conducted because of the hazard complaint that was turned in.
Thank you. Any other commissioners have questions?
I do. I have one more since you talk about MSHA a fair amount now. It's the largest, or probably the most involved, maybe largest isn't the right term.
It's the most present.
Yes.
Yes.
That's, so, am I correct, though, that most of what they are tasked with is the impact your operation has on your workers?
Correct.
So,
Yes.
not the impact it has on the town?
Correct. So they are focused on the workers for all those issues that have been raised, dust, noise, air. The ones that are going to be most impacted are the workers, right? So that's we are testing closest to the source.
It's your issue.
You don't have the right to talk.
So I'll give you the example of noise. So we have a hearing program and MSHA does hearing testing, right? To make sure our employees, that their hearing is not affected by the operations. If you consider how noise travels, it's reasonable to assume that the nearest neighbor to our operation on the north side is 6,200 feet away. And there's a ridge line between our operations and the neighbor. So the noise that my employee is hearing is significantly more important and higher than anyone else around the town.
But presumably those employees have health and safety equipment as well,
Yes,
which is obviously not something that residents 6,000 feet away happen to have.
yes, but I sit 100 feet from the equipment, and I don't need hearing protection, for example, right? There's certain areas that require hearing protection. I'll use that example again. There are certain tasks that might require different PPE, and we'll provide them when needed. But our employees they're using their regular PPE, which would be a hat, the vest, and steel-toed boots, and they're not required to use more than that unless in a specific area of the plant. No. Thank you.
Do any other commissioners have questions?
With the new equipment, I think you went on and said that it's going to eliminate or reduce dust in your summaries, as well as noise pollution. Would you be opposed to a stipulation saying you keep that same requirement you already have? In your testing? Would you agree that the new equipment would be lower
Yes, yes.
in testing? And
Yeah.
if not, you make the appropriate changes to meet your current.
Yes, I'm just trying to understand what exact testing. we would be doing.
Pretty much all the testing you're doing currently. So, we could
Yeah, we're
compare the
gonna
old
con-
testing to the new testing. And, if anything is above, a couple of months down the line, you make the appropriate changes.
We will continue to comply with the regulations in place, yes.
But you're so far below the regulations now, so you're saying you will go up possibly if needed.
That's not what I'm saying. I'm saying we're going to keep complying.
Mr. Ryan, I appreciate your question. I understand where you're coming from. But again, you don't have a regulation that
Yeah.
regulates that.
All good.
Any other commissioners have any questions?
Now, all your agencies are they regularly on the yearly basis, monthly basis for inspection? Or they, like you said, they're gonna walk in at any time at their convenience to inspect? Or
It varies. As I said, MSHA is the most present, but each of them has there's a different cadence for each one and what they require. It can vary by permit and so forth. Maybe I can highlight another one, which is DEEP. So obviously DEEP is the state agency. So just over the last 3 years, in our Plainville site, DEEP has been on site for three different occasions related to the quarry. On October 18, 2023, DEEP conducted their Aquifer Protection Act inspection and found no violations. There were 5 recommendations that have all been either completed or are in progress. In 2024, DEEP also had their new community-focused air monitoring. They're called GMAP vehicles, Geospatial Measurement Air Pollution Vehicles, drive by our facility to collect PM, particulate matter samples. Again, no issues were found. Lastly, just this past July in 2025, DEEP conducted another inspection of our Plainville facility following a community complaint. They inspected our site. We provided them with the requested information. The inspection, once again, did not yield evidence to support the complaints or suggest improper activity.
Thank you. Any other questions from commissioners?
Madam Chairman, I think you're familiar with the treatise or writing of Janet Brooks entitled Environmental Interventions Before Municipal Land Use Agencies. And in it, she discusses the fact that to find a violation, it almost requires expert testimony on the topic. And there's been no testimony whatsoever that this equipment would be reasonably likely to cause a reasonable pollution. So I don't think that the intervener has even done enough to get through the threshold here tonight.
Thank you. Does anyone else have anything to say representing the applicant?
I would just say I want to thank the commission, and it's really memorable what you guys do, and you dedicate your time generously to this, and I appreciate the diligence you're going through and how you are being respectful and attentive to the community. As Attorney Galsky presented, we do feel there's no evidence of the unreasonable adverse environmental impacts from our site plan application. I believe the commission has given the intervener the opportunity to present their case. There's not been substantial factual evidence of environmental hardship presented. Moreover, as a commission, you have conducted investigation. You have asked us questions. We have presented you with data. Our operations and application are in full compliance with the applicable statutes and regulations and have no environmental effect. Therefore, we really are confident that we have met or exceeded all the requirements for this site plan application to be approved. Thank you very much.
I know I'm late. Can I ask one more question?
Sure.
I just had a question on a related, which is, can you assure us on the record that no wastewater discharges to groundwater occur on site?
That's correct. We do not wash our stone on site. That would create a process water, which would require a wastewater permit. We do not do that, and we do not require wastewater permit. Stormwater, we have a permit, but they are two different permits.
Thank you. Anyone else? Georgia?
I just want to.
You have to go up to the microphone if you're going to come up. Just state your name and address again for the record.
Georgia Bedell, 28 Pequot Road. I wasn't going to say anything else, but there were just a couple things that I was pretty astounded on hearing. As you said, MSHA and OSHA, their only job is the employees. They have zero jurisdiction. We spoke with them. Zero jurisdiction over anything off the site whatsoever. So anything that raises above the site, they do not have jurisdiction over it. There's a lot of our goals that I heard tonight, but they don't follow through.
Excuse me for 1 second. Do you have proof of that?
How many things since I've started this whole thing that they've said are goals that still haven't happened?
I don't have data.
But my job as an intervener, I don't have to actually have scientific
Right.
data.
But the agencies that oversee,
If they can prove to us that do they have the proof? Do they have proof? If I don't have proof, do they have the proof tonight? Right now?
well, they've referenced how many agencies that they've all complied with the testing.
Right, and I've just told you, MSHA and OSHA, I'm here as a resident. They protect the employees. Fantastic.
So there's
That's what
other
they're
agencies on the list, correct?
Correct.
Okay.
And they had spoke about Susan from DPH. We actually have an email from her from 5 days ago stating that she did not do any of that testing, and it has not been done. I have that. They said that it's 6,000 feet away is the closest. 3,024 feet is the closest home.
So do you have that email that you can provide
Yes,
to us?
we do. 6,228 feet is to Pinnacle Rock, not to the closest home. There are so many unresolved issues in this submission that I really hope that you read it all and deny without prejudice. Thank you. Also, on record, he did state that they do dump into the Quinnipiac River. He said that to you on our last meeting. Thank you.
Thank you.
Somebody's lying here.
Anybody want to address the issues raised?
Miss, I can read you the email from Susan if you want.
I don't want to read it. I want a copy of it.
I'll email it to Bossy.
Chris, you want to talk about the discharge?
Yeah, so our discharge off that quarry, Chris Costello, Tilcon, 300 Woodford Avenue. The discharge from our stormwater permit going off that site actually goes into the MS4 discharge, which is the town's stormwater discharge. Then either The MS4 in Plainville either goes into Pequaback River or it goes into Quinnipiac. So that's pretty much the
But-
stormwater permit.
But wastewater from.
There's no
hosing down
wastewater.
trucks
There's
is
no
No
wastewater.
wastewater.
None.
It's only stormwater. And it actually goes into the town system first.
And the water from hosing anything down from the dust control and all of that is not classified as wastewater.
No,
And what happens to that water?
it does not leave the site. We have sweepers that take up that water.
And then what happens to it?
What?
You said it doesn't leave the site. What happens? Is it recycled and reused on site? How does it not leave the site?
You're talking about dust control water?
Yeah, is it just recycle through?
Yeah, and it evaporates.
And hosing down trucks?
We don't hose down trucks. Are you talking about dust control?
I must be,
Yeah.
I must not remember our discussions properly.
So when we talk about dust control, I showed you guys those nozzles, right? They're made especially for water to evaporate from them. Okay? So when we're using that on site, it's at and I don't know how to describe this, a particular level that is easily, if that will evaporate easily. We do also have the sweepers, so we don't require and we don't have a wastewater permit. The stormwater discharge, that would go into sediment ponds in our site. We would allow it to settle, and then if needed, we would discharge through the basins. When it's discharged at our property line is where we test. From there, it goes to the MS4 system from the town. We have a copy of just like we have a permit with DEEP, the town has a permit with DEEP. And then what happens from there, John Bossy can probably explain best, but it could end up in the rivers, yes. But that's after it's been through our sediment ponds and gone through the outlets.
So the dust control is high pressure, low volume, so it mists instead of pours out, so there is no discharge from that water.
My understanding, again, I'm trying to remember 1-2 meetings ago, this has been going on for a while. There's no hosing down of trucks, there's no watering down of material in trucks.
Well, there's dust control in the truck?
Yeah, there can be dust control in the trucks, yes.
And.
Right, but go ahead.
And so none of that water physically leaves that truck.
No. We don't hose down the trucks. The water, the load is dust control is put over the load, not, the truck is not washed down. Those are two different things.
It surprises me you don't have to control dust on the trucks if they're in that quarry.
We control dust on a load of stone in the truck, but the actual truck body does not get hosed down.
But clearly, I mean, there's a picture. Your activities raise dust all over the place beyond the dust control in the machines themselves. That's why I'm surprised you don't have to do something to, that dust lands somewhere. I know that, residents are saying, well, it's landing on our property, but certainly, I would imagine, most of it comes back on your property. But it's not something you have to deal with, or
As
at
far-
least not in that manner.
No.
Yeah.
I would like to also clarify what was stated about Director Susan. We do have copies of what we sent her. This was, again, also sent to the town planner and the Representative Martinez. She did not conduct tests, that is correct, but she did review the data of the test that MSHA conducted. We also conducted extra tests that were then evaluated by the third party that we shared with her. So if you guys want copies of that, I have that. I will correct myself. The closest neighbor, it was in my notes, it's 2,600 feet. And that's on the north side. On the south side, it's 1,200 feet. So the distance is more than double on the north side than the south side. And it's on the other side of the ridge line, correct?
Any other questions from commissioners? John, do you have anything to add?
The only thing that I have to add is if it's on, is that I had handed out a procedure or a kind of a cheat sheet for you to guide you through if you choose to make approval or denial tonight.
Before we get there, I apologize, John. I didn't know where we were going, so before we get to that, do we have anything official from the retained counsel?
Both the town attorney and the retained counsel have provided myself with confidential advice on how to handle the matter.
Okay. That makes it less helpful to me.
We're part of the town, we should know what it is.
Excuse me, you can't speak.
Okay.
I mean, our counsel is here tonight if you have questions directly to direct towards to him. He's sitting right here in the front row, and he's willing to answer any questions that you may have directly related to legal issues regarding this application.
Yes, I think I do. To start with, the intervener alleges 7 or 8 different concerns, which she maintains necessitate us denying without prejudice. And my question would be, well, I'll start with what's hopefully an easy one, which is she correct that if any of those things were true, this body has a right to deny the application without prejudice? Let's start there.
Well, I wouldn't put it that way.
Can you put the mic on and just put your name and address?
Yes, my name is John Bradley, 225 Asylum Street, Hartford. I'm with the firm of Halloran Sage. And I'm assistant town attorney for the past month and a half or 2 months.
Can't hear you, sir.
Okay.
Want to use this microphone, John?
Does this, you can hear me? All right. Okay, that's better. All right. This is a site plan application, as you know. And the commission acts in an administrative capacity in connection with a site plan application. This is a permitted use in a quarry industrial zone. In a administrative capacity, you have to focus on your regulations and whether or not a site plan application that's filed for new or replacement equipment, right? This is for permanent equipment to replace temporary equipment. Whether or not that complies with your zoning regulations. And not go outside of your regulations. The fact that we have interveners makes it a slightly different analysis. Because with interveners, you need to consider whether or not there's evidence or proof that this new replacement equipment would cause unreasonable pollution. If you find that there is no likelihood that this equipment causing unreasonable pollution, then that's the end of the inquiry. If, on the other hand, you find that the installation of this permanent equipment will cause unreasonable pollution, then you need to consider whether there are feasible and prudent alternatives. And if you find that the new equipment is likely to cause unreasonable pollution and that there are no feasible and prudent alternatives, then the application should be denied. But the first step is whether or not, now that the interveners have come in, the first step is to determine whether there's evidence that this new permanent equipment will cause unreasonable pollution. If it doesn't, then that's the end of that inquiry.
It's a higher standard than that. It has to be reasonably likely.
Could you put your mic on, Attorney Golsky?
It's a higher standard than that. It has to be reasonably likely that it will cause unreasonable pollution. It's 2 steps there. Reasonably likely, unreasonable result.
Can I ask a point of clarification? So the issue before us, or the portion of the site plan is, as you said, solely for the change out of the old temporary equipment to the new equipment. We're not talking about anything else that's occurring on the site but the change out of the actual physical equipment, versus we're not talking about the trucks, the process of which the trucks are carrying the rock to and from. We're not talking about any of the other quarrying processes, solely about what is before us for the application, taking temporary equipment and replacing it with new equipment. Am I correct?
Yes, I agree with that. That's the application, and that's the application. It's not the entire global picture of quarrying. Quarrying is a permitted use in this zone. So it's simply, the application is for replacement of the temporary equipment by permanent equipment. And that's legally what you need to focus on.
And if the equipment before us is top of the line, state of the art, best management practice in how it operates, and you can't get much better than that, and there's not another alternative beyond that, and it adheres to the regulations that we have to work with for what we're regulating, then we have a decision to make.
That's right.
Thank you.
Can I ask one follow-up on the
Yes.
pollution part? Does it matter at all for our analysis? Obviously, there's equipment there now, and it's, let's say, and this is a hypothetical, and I apologize, I'm not suggesting this is true, but for purposes of our analysis, let's say we thought that, we didn't, the equipment's there, it was approved, but now we thought it was unreasonably polluting. And they want to switch out to new equipment that we might say unreasonably pollutes. Does it matter at all that the new equipment wouldn't necessarily be making it worse? Do you understand what I mean by that? Like, if, say they were already unreasonably polluting, now they want to put in different equipment that's also going to unreasonably pollute. Are they free to do it then? Because it's like, well, we're already here. Or would we still, in theory, have the ability to regulate that?
I don't think you ever reach that stage, because if they're unreasonably polluting and the other agencies were doing their job, they wouldn't be unreasonably polluting.
I'm just trying to get whether,
I don't think it's a good question.
fair enough. I'm not surprised, but I disagree.
Excellent question.
We have other, we
I'd
have,
still like
we have
an answer
Clean
from our
Earth in
council.
town that had a fire, and they had an air permit, and they got shut down. They can't operate. They don't have a permit. You approve the site plan, but you don't approve the workings of it.
I understand that, but if we are allowed to, if the process allows that, if we were to conclude that there was a reasonable likelihood of conduct that would result in unreasonable pollution, I apologize, not quite exactly right, but right? If we were to get to that analysis, my question is it undercut if what was already there was doing the same thing?
All I can tell you is that it's up to you
Okay.
to make the determination whether this particular application, and installing this equipment that's been requested, is reasonably likely to cause unreasonable pollution.
Okay.
And I think you need to focus on what's being proposed rather than look forward rather than backward.
Okay.
Thank you.
Yes.
I have a question.
Before you guys conclude, I was informed that the email from Susan is sitting in my email, and I will get that if you want to, if it's important in the decision.
Yeah, I think so. Is your mic on, John?
It says it's on.
Okay. I would like to see the email.
Okay, so I'll go down at my desk and I'll get the email.
Okay.
Okay.
I can have my phone just show her if you want with the email right on it from her health stamp. and
I
everything.
will get,
Okay.
Yeah, I'd like to read it from a copy for the record. It needs to go in the record anyway.
We need him to be here to ask the question.
No, you don't need him to be here to ask a question.
So I'd like to ask the attorneys a question. Tilcon is coming for a site plan to replace temporary equipment with new equipment. If they didn't replace it, they still get to do what they're doing.
Yeah,
They can withdraw it and continue on, and this becomes mute. Is that a correct statement?
yeah. They could bring in more more temporary more movable crushers. There's nothing
That
that
wouldn't fall under our purview.
No.
Thank you.
another agency.
Understood.
Any other commissioners have questions at this point? Okay, then we'll just wait for John to get back. Yeah, go ahead.
Madam Chairman, could I ask one more question? Or should I wait?
Yeah, you could ask him another question.
Sorry, one more question, because there is. I apologize. Sir, one more question, because there has been some disagreement, I would say, between the intervener and the attorney for the applicant as far as the extent of the intervener's burden. And I am struggling to determine if there is if it's simply a judgment call on our part, or if we have a legal standard from your opinion that we can use to evaluate whether the intervener has met the burden she is required to meet under the statute.
That's what-
And please make sure it's on if it's not. Thank you.
Yeah. Well, I don't know if I'm waiting for,
Yeah, we'll give it a second,
Yeah.
that's fine.
it generally does require expert testimony to prove unreasonable impairment. And it is true that the intervener bears the burden of presenting evidence upon which you could determine that it's unreasonable impairment
Yeah.
or pollution caused by this installation. So it is true that the intervener has the burden. It's also true that it doesn't make you, the Planning and Zoning Commission, a little EPA or Environmental Protection Agency. You have to focus on your regulations, but you're not supposed to approve conduct which causes or unreasonable pollution. And that's your judgment.
Thank you.
Yeah.
All right, I'm going to read this email that was on Friday, January 30th, 2026, 10:04 a.m. Susan Lonzak, lonzaks@southington.org. She wrote, "Hi Harlan, I don't have an update on testing yet. You are correct that State Representative Martinez and I are working on the data. I did file a comprehensive FOIA request, which was received and accepted. They initially requested additional information, which I provided. I was advised upfront that the request would take some time to process, and I was later notified that it was paused during the government shutdown. As a result, I have not received records yet and was told to anticipate a wait longer than 30 days. That said, I will follow up to check on the status and see whether any materials retrieved so far can be released. I will keep you updated as I learn more. Susan," and this is Susan Lonzak, MPHRS, Director of Health.
What was the date of that?
January 30th of 2026.
So as I stated, on August 21st, 2025, we sent Susan the results of all the MSHA testing at our site. I have copies of that. We also conducted our own testing that was sent to third-party facilities for the result, and that was shared on September 5th, 2025, with Rep. Martinez, Susan, and the town council.
So in the email, though, what's the data points that she's looking for? Do we know what was FOI'd?
I am not aware that request did not come to us. It must have been to an agency. Do you know? MSHA? Yeah, so it went to MSHA.
It was already shared. Exactly.
Again, I can share the results.
Now, again, that's a different overseeing agency.
I understand that. But for transparency, we might as well look.
Do you also want the one that was sent to Rep. Martinez? Which one? Yeah, so the FOIA was all the information that was shared with Susan. So we shared the noise and dust sampling from June 7th, 2023. We also shared one from 2025, so 5/22/2025. That was the one in response to the complaint. And then I've included a review message from the inspector, because this, when I look at this, it's hard for me to understand. That explains what the data is showing. But if you would like, my health and safety manager is here as well, and he can walk you through in more detail.
Thank you. Do any other commissioners have any questions at this point? Okay. Anyone else have anything to add? No? John, do we need any additional information for you or for anyone? Or do you see any reason why we should keep this
Well,
site plan?
keep in mind that the clock is ticking, and without an extension, the period for you to make a decision expires. 65 days will expire. By my count, we received the application, you as a commission received the application on December 16th. And if you add the days in December plus the days in January and so far in February, I count 63 days. And the deadline is 65. Well, I'm mistaken. It was December 9th that your first meeting in December was. That's the date that it was accepted. It was received by my office on December 5th, and by regulation, the next regularly scheduled meeting is the official acceptance date.
Okay. Commissioners, what's your pleasure?
I think we've been sitting on this long enough. There's enough evidence to make a decision this evening. That's my opinion.
Okay. Someone like to make a motion?
I'll make the first motion. The Planning and Zoning Commission has, after consideration of the intervener's testimony and evidence, finds that the proposed site plan and associated activity is not likely to cause unreasonable pollution, impairment, or destruction of natural resources.
I'll second that.
Is that a motion to approve the site plan? Or is that a motion?
We have to do 3 motions. Yeah.
And someone like to make a, second on that?
I did. Excuse me, I did.
Any comments or discussion?
Well, the only comments I have to make is, first of all, is the application is strictly for the removal, the replacement of the equipment to better classify it. And the second thing, I've been living in the neighborhood for 40 years, and, you know, to my experience, I still see birds, I still see deer, I still see bear in my neighborhood, so, you know.
That makes it okay.
They're still there.
Any other comments or discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed?
Aye. Opposed.
So we got one. Any abstention? 5 and 1. Motion carries.
Based on your first motion, you don't have to do step 2.
Okay. So then we need a motion to either approve or deny the site plan that's in front of us. Who would like to make that motion? And make it in the affirmative?
Madam Chair, I'd like to make a motion to approve PZ 01/26, number 1, site plan Tilcon Inc., 0 Loon Lake Road, 475 New Britain Avenue. Proposed installation of permanent stone processing equipment.
Second.
Can you add this comments in there?
The Planning and Zoning Commission, after considering the intervenor testimony and review of the regulations, finds that the site plan conforms to the requirements of the zoning regulations and is not likely to unreasonably pollute or impair the natural resource of Connecticut, and approves the site plan submitted by Tilcon for improvements associated with the installation of equipment at their quarry located at 475 New Britain Avenue /0 Loon Lake Road with the noted stipulations.
And there's no stipulations.
That's it.
Okay, you want to add that to your second? Can I have that back?
Yes, I'll add it to my second.
Okay, so we have a motion and a second. Any further comments or discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed?
No.
Any abstentions? Motion carries 5-1. Thank you.
I know it's hard for you to understand.
Let him clear out.
Residents of Plainville have nothing to say?
We still have a
We voted on it. We have nothing to say, right?
There's not a place for you to speak, and we have a portion of the meeting to continue with, so as soon as you clear the room, we need to continue with our meeting, okay?
You should have given any questions to the public.
We don't,
Give
there's
everybody
no,
else time.
this is a site plan application, and based on the regulations, there is not a place for the public to speak.
And
You
the
know,
regulations have
Sir.
regurgitated food. You
Sir,
can force it down our throats.
sir, you need to
You know,
leave
but
it.
at least post on the, we're at the meeting so the public can say something.
I've asked you numerous times to refrain from speaking. There's not a place to
You can
speak.
speak and I can speak. It
Oh.
goes both ways. Don't forget, it goes both ways.
Okay, is everybody ready to move on to item number 2?
Yep.
PZ 01/26, number 3, site plan 105 West Main LLC, 105 and 111 West Main Street. Proposed mixed-use development, medical office, 7,120 square feet, 14 one-bedroom residential units, 6 two-bedroom units, central commercial zone. Go for it, and then just, if you can get yourself to a mic once you're all set up.
Thanks, Johnny. Good evening. For the record, I am Tom Daly. I am a professional engineer with the firm of SLR Consulting. Also with me this evening is Johnny Carrier from the Carrier Group, who is the applicant.
and actually the owner also of the property. But we're excited to be back before this commission. So this is, I think, our third trip, maybe just our third trip. We started with you with an informal presentation for this application, and then we went on our way and we received our wetlands approval. We then came back to this commission and spoke to you about the process. And then at the last time we were before you, we received approval from this commission for two items. One, we worked with you to get a text amendment. Your POCD is clearly encouraging walkable, increased density, more vibrancy in the downtown and the urban core, and also and so we revised our. You were supportive of a text amendment to kind of get a little bigger density bonus when you're in a certain area of the town. In addition to that, we also then had to do a zone change. This parcel had been encumbered by 3 different zones. It's only a 3-acre parcel. It was encumbered by 3 different zones. There was an industrial parcel to the rear, which is somewhat of a remnant of something else. And you allowed us to have a zone change to kind of bring those 2 parcels to the same zone in the front. So here we are, what we believe is to be potentially the last time we're going to see you on this. But we're here for the final part of this, basically the trifecta of an application, and that's to come in with a good old-fashioned site plan application for you. So we have put together, and this is the same exact plan that has been before you, even when we went back to you with the informal presentation. Things really haven't changed much. But the proposal before you this evening is for a mixed-use building. So in this central district, you're looking for mixed-use development. So on part of this application, this is as I said, the parcel is made up of actually 2 small parcels. It's just a stone's throw down the street here of where the location is. It's on West Main Street, right across the street from Strong Street. So the proposal before you this evening is for a mixed-use building. The ground floor will have office on it, but your regulations allow you to have up to 2 ADA units on the ground floor, and we're taking advantage of that. And then we'll have 2 additional floors of apartments up above. As part of your text amendment, you capped the amount of units that could be done at 20 units. If you do the density calculation, we can actually get much more units, but you had a cap at 20, and that's how many we're proposing on this. So that's about 7,000 square feet of office space on the ground floor, and then up above that, so as I said, 2 units on the first floor, and the remaining 18 units would 2 stacks of 9 units on there. We've aligned the driveway to be directly adjacent to the opposite street. That's good transportation planning. You'll have the building to your left. As part of that, we'll also be improving the new streetscape. We'll replace the sidewalk along the frontage, add some street trees. And the building has been designed, essentially it is 2 entrances. So the commercial entrance would be on this side of the building. So if you're coming to the office, but the nice thing is, from a residential standpoint, you come to a different size, and you'll basically come through an area. We'll have an outdoor courtyard there with a seat wall around it, and you'll come in through this landscape element or this patio area. That will also serve as the outdoor amenity space for the residents to go out there, sit out there on there. And so as part of that, we have a fairly straightforward parking lot. We come through here. Instantly, the rear parking lot actually acts as a circulation for a fire truck and larger vehicles. We did do the parking calculations. Your calculations asked for min and max. To be honest, we're closer to the max. We have 80 parking spaces here. And one thing I would note is you have a higher standard for medical office, so we looked at the most conservative approach here. If it goes to general office or some other, lesser use, we'll have some extra parking on that. One other thing we're proposing to you is, as part of the zone change application, your POCD talks about a potential trail going along the river in the back. The applicant has offered to the town that we would provide a 10-foot easement through the property. And actually, if you look from a block plan, if that trail ever gone through, the two connection points are very far. As you know, this is a strong residential neighborhood. This gives you basically a mid, if the trail ever gets built, you'll get a mid-block, and then the neighborhood will get right onto that trail system. So the carriers have offered that as an easement to there, and actually, if the trail gets built, they're committed to leveling that area out and getting that, because it really benefits our residents too, to have that trail connection.
Can I ask one question quick? You were pointing to the main entranceway for the commercial building.
Right here, yes.
So your handicap spaces are supposed to be closest to that.
But we also have to have a ramp at a certain gradient. So
Right.
they come off here, and they'll come up here, and this is a gradient to get them into the front door.
They're still supposed to be like right by the door.
We can take a look at that. I mean,
They really
the whole parking lot, yeah, the ADA for the residential's right there, but I hear what you're saying, you're over here, because Johnny, is the door, did the door end up being at the middle?
Yeah, not, John Carrier, 105 West Main LLC, right here in Plainville. Yeah, this is accurate the way it's shown. We could definitely take a look at shifting that over.
That's not a problem, we can look at that.
What's the grade there?
Well, the whole site is generally graded at ADA levels at less than 5%, so we'd have to take a look at, but generally, we're flat across the building anyways.
Right, because you're inch of height for every foot of length, so you don't
Yeah.
have that much to
Yeah, so
ramp.
we may not get it right in front of the door, but I think we can definitely slide it over.
Just check the ADA regs, because you're supposed to be like right there. Yeah. Like the closest spaces to the door.
Yep. Yeah, I don't know, the grading, but, we have, that's absolutely no problem looking at that. I mean, I think the door might have evolved. Sorry, one more. Yeah, I mean, generally, this parking lot is very flat, so, yeah, we'll take a look at that. I think the door might have evolved over time, and maybe our parking plan didn't catch up with that.
Okay.
So, as part of that, so the,
Because the architecture is not fully complete.
Yeah.
Either moving the entrance
Yeah.
or bringing the parking spots within.
yeah, so-
Whatever's easier for you
Yeah, sure.
from a,
Yeah.
cost standpoint.
Yeah, we haven't fitted out that space totally on there, so like I said, it's about 7,000. But yeah, your good point is maybe it's easier to move the door than it is to there. The project has, partially, it is in the floodplain. And we provided your town engineer a calculation to show that we have no net increase in flood compensation there. And part of that is this basin is part of that is excavating. We also have actually added some permeable paver parking lots for low impact development. Our lighting is all down, dark sky compliant, down lights. We provided a photometric plan that showed that we have a 0-foot candle at the property line. And even though it's a tight property line, we had to get lights that were very appropriate for this site. We worked with a lighting manufacturer and picked those out. We have all native species that are on the plans in terms of landscaping. And I think we presented to you before, first-class building. Really, we feel strongly that that is going to be, it's going to be, we hope to be the best looking building on the corner, and then maybe that'll actually get more development going on in there. I think one other thing is we were on your agenda last meeting, but we had received town comments from your town engineer. Subsequent to that, we have resubmitted the plans and provided a response letter, and I believe your agenda item says that those items have been addressed. We clearly have to, we still have to go get a building permit. We have to get a DOT encroachment permit because that's a state road, so where we put a curb cut and utility connections, but that's a post-U approval. With that, myself and Johnny would be more than happy to answer any questions the commission may have.
Did you include the photometric page in the plan that we got in the packet? Because I don't see it here.
It was likely in the first submission.
Okay,
It was
that's
probably
fine.
not in the revised submission because the revised submission addressed Mr. Bossy's comments.
Okay. No, this goes to SD5.
Yeah, that was, you probably have the revised set. What's the revision date on, and sometimes actually we submit it as a sheet 1 of 1 because it's prepared by a lighting manufacturer, not by us.
Yeah, I just don't see it in here.
It says revised January 5, 2025. I'm wondering if
Yeah,
that's...
so those are the newest set.
I was gonna say, I'm just wondering if that's a typo.
What's it say?
January 5, 2025.
Yeah, that's, oh,
No, this one's 26.
Well, it says received 26, but their revision date on the top
Yeah.
says,
Oh, where's that? Oh,
so.
I'm wondering if that's a
the most
typo or...
revised plans are, no, well, we started this process
Okay.
in 25, but the most revised are the February 2nd, 2026.
Okay,
Town
we don't-
council.
so we don't have
But
that.
at the end of the day is, they were fairly minor, and it was addressing some minor technical, actually a lot of labels, clarifying things, but I would say there's nothing materially different in the plans that you see in front of you than the revised plans.
Can
Yep.
I ask a couple?
Yeah,
Well, the lighting plan and then whatever else was revised in the newest one, because this one's from April 23rd of 2025.
This is the full set of the revised.
Because I didn't see the lighting detail in here either.
Can I ask a couple parking questions while
yeah.
she looks? So in, relating your comments to
Yep.
what we've got in front of us, which again, is not, it doesn't sound like it's the latest submission. You mentioned 9 EV parking spots.
Yes.
Plus 1 ADA.
Yep, so there's 9 EV parking spaces right here.
Sure. And
The
then,
current code, state statute says they have to be EV ready in your code, but I'll be honest with you, we would like the commission's, EV is still something we're all trying to figure out.
Sure.
So what we're finding on projects is we're committed to putting the required part of your code that says how many spaces, but it may evolve a little bit. When we have to talk to Eversource, we have to do that. We're committed to there, and we'll have to work out those details of where they actually fall, but we are committed to the amount that's required in your code.
and then with one of them needing to be ADA,
Yeah.
do you anticipate then that you would have you have a block, in theory, a block of parking that's EV, but are you putting an ADA spot over there? Or
Yes.
are you going to convert?
Yes.
Okay.
Yes, that's what we're doing on other projects but once again, you also could make, one of these spaces a thing. So we'll have to work with the electrician, but, 10% of the spaces, or at least one, has to be van accessible.
So
Yeah.
the understanding is that the switchgear and the power, as long as there's
Yeah.
capacity at the pole,
Yeah.
Yeah.
gets brought into the building, and then you have conduits that are run
Right, to where you
to be
need
EV ready to those
Hmm.
places. Now, when you do have EV chargers, a lot of times you could energize 2 parking spots per spot.
Hmm.
So most likely we'll end up putting that in series of 2.
Yes.
Yeah.
And then, curious, it sounds like one of the potential uses for the office space is medical.
Correct.
My concern would be particularly if there's an EV charger on the back side of the building in one of those
Yeah.
ADA spots, is making sure that your ADA tenants living on
Yeah.
the ground floor, that those spots are signed in some way or whatever it happens to be, to make it clear that those are not for, presumably, not for users of the facility, they are for
Yeah.
those tenants, so I would assume.
So my anticipation is to have the apartments have their parking spots labeled.
Okay.
And have the EV spots as overflow spots that people can park at while they're charging, but would have their own spot. So it wouldn't be a designated spot for one apartment.
Yeah.
As you know, turnover and who has them, et cetera. And the reason we're trying to locate them somewhat here is because the concentration of the lower level commercial or office or medical would be
Yeah.
on that front half.
Absolutely.
And then the residents on the back. So we're trying to find a good mix that would work.
Yeah,
overall.
no, for sure, and yeah, my only other follow-up was because you actually have plenty
Yeah.
of parking.
Yeah.
Is if you thought medical was going to be a use, would it be a consideration to add 1 or 2 additional ADA spots as you may have a outsized demand for those spots depending on the usage of the building, just something to.
Yeah,
I understand it's not required
yeah.
and you're meeting what's
Yeah,
required.
yeah, and we do a lot of medical office, and remember, this is only 7,000 square feet. But we have not done that. Where we have done that is more on senior housing or more acute care, assisted living, as we do up those numbers. But we have not seen that as a desire by our tenants. But once again, as I think as the chair indicated, is this parking lot's relatively flat. There's flexibility. It's not a very steep site. It's a relatively flat site that we can accommodate those goals. And also that $7,000 may also be it could be two uses, right? I mean,
So where this comes from is to answer your first question, the EV, a lot of it to me is market driven. So I just finished a 10 unit and I made a level 2 charger ready for every unit, and I haven't had one, it's been a year. So that doesn't mean it won't be here, but it's ready, it's there. So as people come in, we have that option. And for us being, kind of the builder and the planner. The medical use, and the reason we did that is because I was I would visit Pro Health right across the street. It's now closed. I still go to Pro Health, and I either have to drive to Bristol or Plainville or Southington. And so I was actually in a physical, and my doctors got me on the phone with somebody else, like, hey, they're doing this thing, but I could not get it approved fast enough. So that says, it is my intention to try to go down that route. My very good backup plan is I'm currently housed and located in my office at 68A South Canal Street with my uncle. We have outgrown the place, so that 7,000 square feet would quickly double as my office and a 2,000 square foot design center for all my customers to visit, to pick selections and things like that. And I had relayed that at one of the earlier meetings. That was the backup plan.
The good news is sometimes you see mixed use in Connecticut and the ground floor goes unused. I think we're quite confident on this one that we have not only one plan, but multiple plans. So I think we want to activate that ground floor. We don't want it to be left unused. So the good news is we got multiple plans to get that space activated.
One small little fact too is Tom mentioned the sidewalk going from 170 or 372 or West Main coming back. Obviously, we would maintain that. That would be on us within our parcel. The town would strictly have an easement so that the public has access to it. That also helps me on the liability side, is opening it to the public without fee, as long as I'm maintaining it in an option. But it doesn't come at a cost to the town in any way, shape, or form.
Thank you, guys.
I'm just gonna ask again you said there is a sheet on the photometrics, because I don't see it on the title, on the front page?
Yeah, I'd be more than happy to submit it. I apologize if it didn't, but we typically submit it as a sheet 1 of 1 because it's actually not prepared by our office.
Okay.
It's prepared by a lighting a manufacturer. It's a special software they have. We typically use a company called Apex, which is out of Avon. So somewhere maybe in that packet, but if for some reason it's not in the packet,
It's not here.
I will get John but we always, on every one of our projects, we get the lighting photometric done to make sure that we're meeting your standards.
We're just used to getting it like stapled with.
Yeah, I noted, and I'll get you.
Our construction practices, when we actually pick the fixtures, there's another lighting plan done to make sure it matches what was approved.
But
Yeah, okay.
so we have no objection to taking a look at the ADA spaces, and we have no objection to getting John Bossy, for the record, the photometric plan.
I've got the original here. It's not included in the paper copies. I didn't get an opportunity to look through the digital copies, but I remember reviewing it because it would have been a comment, because that's one of the things that I know that you're well aware of that you need to address.
And I think actually there was a comment from you about house side shields. Am I correct? I think you might have, or shielding, or the type of lighting.
Details in here, but just not the photometric.
Yeah, but we will get a full-size copy in there. To be honest, it's been submitted a while ago that I've kind of lost track a little bit of where we are, because I think you had a busy agenda, we got pushed off a little bit. But we did do, Apex did a photometric plan, and we'll submit that to show the town that we're compliant.
And I actually have it, but would have to email it, I'm not gonna bother you
Yeah,
guys.
yeah, are you?
But
no.
I do, I'm proving that I do have it.
Yeah,
Check it
okay.
one time. There you go.
I mean,
There you go.
I remember.
That makes you feel better too.
It makes me feel a lot better.
Now I feel really good. 'cause
I remember seeing the detail because when I was reviewing the lights, I was checking to make sure that they had the right color, and I was
Oh,
going
that's
through
what
the.
you did.
Going through the regulations point by point
yeah.
on the lighting, because I knew that,
Yeah.
as a group, that you're pretty sensitive to it, but
Okay.
unfortunately, it must be a digital file that I was looking at, and, I didn't have an opportunity when I was downstairs to
Well-
hunt my emails to find it.
We'll print out a hard copy, make sure there's one in the file
Okay,
for future reference.
thank you. Any commissioners have any questions? What's your pleasure, because we have just a small, well, we're missing the photometrics page, so we didn't see that. And then we also have the change that they're gonna need to do regarding the two handicap spaces being in closer proximity to the door, whether they move the spaces or they move the door. So you decide what your preferences are. If you'd like to make a motion to approve it with stipulations, or if you'd like to table it and continue it to the next meeting and have all of the components that are undecided or missing fulfilled.
Madam Chair, just on the architecture part, QA&M is ready to go, but we've done schematics, but we haven't done full drawings. So I wouldn't have that portion for a few months. It's, the site plan and the drawing will be done in conjunction. So it would be my preference that that be a condition, that it meet ADA requirements, so that we have the flexibility to do that in a timely manner. But I don't know if we could do that before our next meeting per se.
I don't see that as a major issue anyway.
It's up to you guys, what you
You
prefer.
know,
I'm okay with it being a stipulation to the motion.
you too?
So include the photometric plan.
Photometric and the,
And that it
ADA.
meets ADA
ADA.
compliance for the parking space, so whether they they
Look-
move the
look-
door or relocate the spaces, either or, as long as it complies.
Yeah.
Okay. So does somebody want to make a motion?
Madam Chair, I'd like to approve a motion for PZ 01/26, number 3, Site Plan 105 West Main LLC, -105 and 111 West Main Street. Proposed mixed-use development medical /office, in parentheses 7,100 square feet, in parentheses 14, 14, one-bedroom residential units, 6 two-bedroom units, central commercial zone.
Second.
With the following stipulations of the ADA
Compliance for the
compliance
spaces. And
Comply.
the photometric
and
plan.
the photometric plan.
You add that to your second, Pete?
Yes, I add that to my second.
Any other comments or discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thank you, good luck.
Good luck, start tomorrow.
All right, moving on to item number 4, which is new business, PZ 01/26, number 6, special exception, 20 Norton Place, Alexander Khan, proposed multifamily structure, addition of 3 living units, R10 zone. And this application requires a public hearing, and we need to set a public hearing for March 10th of 2026. Good evening.
Before you consider a public hearing, there's evidence that currently they're running this as an Airbnb, which falls under your short-term rental regulations, and that also is a special exception. And I don't know from a procedural standpoint how you want to handle it, whether you want to handle them as one, or whether you want to handle them as 2 separate items, one being the Airbnb first, and then the approval for the additional unit second.
So, let me clarify, you're asking us, do we have to make a determination that it fits the criteria of the short-term rental?
Well, your short-term rental regulations, as I read them, is a special exception or a special permit or whatever term you're using, which requires a public hearing specific to that. And your multi-family housing is a special exception also. You have two options, one being to roll it all into one, basically two motions within the special exception, and the public has an opportunity to comment on each one of the components, or have two separate public hearings, one on the Airbnb component or short-term rental component, and then follow that with the multifamily component.
I think historically we've separated them.
Okay, so we'll,
It's just easier to navigate it because then you can vote on it separately.
yep,
So then we're gonna need to set two public hearings.
Two public
then
hearings.
For March 10th. Are you
Okay.
the applicant?
Hi, I'm Lisa Khan. This is my son, Alex Khan.
Hi.
How are you? Thank you for letting us come this evening. So we purchased 20 Norton Place, I think it was in July of 2025. No, 24, I'm sorry, July of 2024. And at the time, Mark DeVoe was acting, or not acting, but he was the
Town planner.
town planner. And so when I purchased it, I was told to me from the previous owner that it used to be the Plainville Creamery, which we got all excited about and thought was super cool because it just seemed like a great, thing for the town to have. So I set up a meeting with Mark to ask him, what we kind of could do with this property and what our options were. And he said to me, first thing he said to me was, Lisa, you should definitely get a survey of the property because, based on what your survey comes back with, he says, I have a feeling that you have less wetlands than our plot plan shows. And you could probably do some, some housing in the basement because the basement has like 16-foot ceilings. It's just, that was where the creamery was. It's a really cool spot if you haven't seen it. So I took his advice and I went out and we got a survey done and we had a soil scientist come out. That was the beginning of it all. We got the whole thing surveyed and turned out, and I brought the survey and the soil scientist report back to Mark. And he said, based on what you're showing me, you actually could fit 3 separate single studio units in the basement. So we thought that was great. He thought that was a great addition for the town. We all did. It's on Norton Place also has apartments complex on it. So we all thought it was a great idea. But it took us like a long time just to kind of figure out how do we do this because, we're just mom and pop situation here, really just as residents ourselves just trying to kind of navigate all this. So we then, from that stage, then Mark left and we kind of got left in limbo for a bit. Not really knowing who to communicate with, but we got told by, I don't think it was Mr. Bossy, but I think the person right before him, maybe Evan, yes, that we should go get an engineer plan for the whole thing to make sure we had the proper parking and all that. So we did that. So we've since then submitted the engineering plans with the parking and, all of the drainage, I guess, but the drainage isn't really changing at all. The property sits on a slope, and so we have it kind of all sloping down with adding swales and stones to it into the erosion plot, and so that seemed to go pretty well. So we submitted that. We have an architect, a professional architect, licensed architect, Dante Boffey, who's designing the 3 units below for us. So we're in a on the go on it now. We don't really know the town procedures though, so we're asking for advice there. So we came tonight and the advice of Mr. Bossy. This is the first step, I guess. And in terms of the short-term rental, I know I got off on the multi-unit thing. In terms of the short-term rental, when we bought the property, I personally just looked it up myself on what the zoning rules were for short-term rentals. I know every town is a different thing right now. With obviously this is the Supreme Court very much favoring short-term rentals these days. So we looked at it and we heard that if you have a multifamily, one of the units can be used as short-term as long as the remainder are used as 30 days or longer. So it just so happened that that's the way we were using ours anyway. So ours has always been, actually right now ours is both units, we have 2 side-by-sides, both units right now are long-term. But we have in the past, and we might in the future, continue to use Norton number 1 as short-term, only that unit. And that's the way we've been functioning. I didn't know, I thought I just needed to comply on good faith, and we have been complying on good faith. I didn't know I needed to go and actually, ask to comply, but we have complied. We've never been in violation of that.
So you're gonna come before us looking to designate one of the 2 existing units as short-term, the other one will stay long-term, and then you're adding 3 more living units on the basement level.
Yes, which is a big walkout basement.
And so are those gonna be rentals as well?
Those will be
Long-
long-term
The long-term
rentals.
rentals, okay,
Mhm.
that was my question.
Yep, that's
Okay.
all it is, yeah.
All
I
right.
will say, the only kind of complexity that I was a little nervous about was that if you guys all are familiar with Norton Place, we live right on the turn there, and there's been a lot of issues with like trucks, because I guess there's like a waste company at the end of there. So there's been a lot of issues with the trucks coming by, and when we first moved in, when we were having some work done to units 1 and 2, just, improving them, revamping, refurbishing a little bit, we had contractors who would come and they'd park on the street. We got into big hot water with my neighbor across the street. She was like, "Oh my God, the trucks are gonna come by and she thought they were gonna ram into, she has a rock on her property, ram into a rock." So it was hard to without a no parking sign, it was very difficult to tell the contractors, don't park on the street, because they just pull in. You don't really think you don't think about the waste down the street. You just think, oh, it looks like a quiet little street here, I can park there. So since that time, we have gotten no parking signs erected outside by the town. So now I feel like, when everybody comes up, there's notice that you're not gonna park there. So I don't feel like that's a risk anymore, although it was a risk in the past.
But you're proposing they'll have adequate parking on site?
We're proposing 7 spaces and to continue with the no on-street parking.
Okay. All right, so then both of these will need a special exception then. So we'll set a public hearing for them. So would someone like to make a motion? Did you have anything else to add?
Just to get some guidance from the town about putting up the notices, how do I do, what do you expect me to do for that? Should I
John
proceed?
can help you with that.
Okay,
Yeah, the whole
The directions
process.
are on the application,
Yeah. I've seen-
okay.
so, I mean, it's relatively simple.
Once we have the. public
Can we
hearing.
do one sign and that's it? Or do we need 2 signs?
It's what it says on the application.
You're gonna need 2 signs.
2 signs,
because it's
okay.
2 separate applications.
Okay, not a problem.
Yeah.
All right,
Okay?
so do we meet again March 10th?
You'll be back March 10th.
To the same type of form that we're in tonight?
Yeah, but you'll actually present what you're proposing for both the short-term rental, and then you'll also present on the addition of the 3 living units.
Okay, now I just saw that the proposal before us came up with the big architectural plans. Is that what we're gonna be expected to do?
You'll need to give us plans, yeah.
You'll need to, you've provided plans for the extra units.
Yes, they have. And I think, if I can just interrupt for 1 second, I heard my architect, I was just talking to him, and he was saying that he met with Chris, is Chris the
Building official.
the building official? So they've been over the plans.
Yeah, so you don't have to have what they had up
Okay.
in front, as long as we have it
Okay.
up here.
Good enough,
And we
thank
can
you.
go off that, and you can just reference that, or if it's easier to put it, you'll be able to pull it up on the big screen so that anybody in the audience can see.
Sounds good. Okay, so
Okay?
thank you very much.
You're welcome. All right, so would someone like to make a motion to approve, to schedule the special exception for 20 Norton Place, Alexander Khan, proposed multifamily structure with the addition of 3 living units in an R10 zone, set that public hearing for March 10th, 2026, at 7:30?
And it's 2 separate hearings?
Yeah, so we'll vote on both separately.
Okay.
So would somebody set that public hearing, make a motion and second that?
I'll make a motion for PZ01 26, number 6, special exemption 20, Norton Place, Alexander Khan, proposed multifamily structure, addition of 3 units, R10 zone, suggested action determination short-term rental, special exception requirement for a public hearing for March 10th, 2026.
There a second?
Second.
Any further comments or discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstention? Motion carries. And then we need a separate motion for the addition of the 3 living units.
I'll make the motion for PZ01 26, number 6, special exemption 20, Norton Place, Alexander Khan, proposed multifamily structure, addition of 3 units, 3 living units, R10 zone, suggested action, application requires a public hearing.
So set that for March 10th at 2.
Set for a public hearing for March 10th, 2026.
I hear a second?
Second.
Any further comments or discussion?
Nope.
Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstention? Motion carries. We'll see you on the 10th.
Thank you.
You're welcome. All right, moving on, we have bills and communications. Did we receive anything else, John?
No, I don't have anything to present to you on bills and communications.
Okay, an item, we did get the packet you sent me for Connecticut Federation of Planning and Zoning Agencies, our annual awards dinner, the conference. And that is going to be March 26th of 2026. And it looks like part of the evening's program is going to be on HB 8002, an act concerning housing growth. So we've got a couple of newer people. This is a conference that we can go to. It's at the AquaTurf. The commission usually pays for us to go attend that. You get continuing education on that, which goes towards what our requirement is. They serve us a night dinner, and there's a talk, and then there's questions and answers that are after. And this is going to be on March 26th at, I think it starts at 5.
Usually.
Yeah, 5 p.m. for the social hour registration, dinner, which is going to be at 6 o'clock, salad, penne pasta, New York strip, veggies, potato, dessert, and then 7:15 there's an awards presentation where they do like the service awards, lifetime achievement, and then around 8 o'clock they start the featured topic. So if anyone would like to go, I will attend, and if anybody would like to go with me, just let John know. Okay.
No lobster, huh?
No lobster.
Oh, well.
But we get their yummy New York strip, which is always good.
After everything we do.
The other rolls are good.
Yeah.
All right, so then we have minutes from our January 13, 2026, and our January 27,
You know,
2006
The
meeting.
January 27th meeting minutes are not complete yet.
Okay.
The reason for that is the Tilcon application will be done verbatim along with this meeting.
Perfect.
So they're a little bit more complicated, and we're still working on
They
the
take time.
details.
Perfect. Thank you. I know it's time consuming. All right, so we have the January 13th meeting minutes. Would anyone like to?
Madam Chair, I'd like to approve the meeting minutes for January 13th, 2026.
Do I hear a second? Any comments or questions? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Planners report.
I have really nothing to report. We have two new applications, and we also have the town executed an agreement with a consultant firm to help in doing planning exercises. It's my understanding also that the manager and others will do some interviews for a planner in the next week or so.
Wonderful. Anybody have anything for John?
No, he's got enough on his plate.
All right, and then we have next is our workshop session reviewing the POCD.
I took the liberty to give you a copy of I think it's chapter 10. And also in chapter 10, I highlighted the page that you made some revisions, I guess late in 2024 and early 2025. Now, chapter 10 is regarding residential development. And there were some adjustments made, some text added, a new illustration was put in place and replaced the old illustration. You can see on the January 25 copy, what's in red are the new things that were added. From the last meeting, it was my understanding that you were going to reconsider or reread this section, or at least we're going to start with section 10 and then maybe go to section 9, which has to do with economic development. I don't know, what you're looking to change, if anything. I know that there is a suggestion to revert back to the 19 version.
So, hang on.
I mean, I can go over the changes specifically. They added 2 new changes to the recommended approach. The first one was a comment in regards to reopening of the quarry. That wording isn't correct, it's technically correct. The quarry was never reopened, it was the activities intensified. That quarry was always open. They didn't quarry to any great degree in the past, but now are considering to operate it to a higher degree. And they're making investments in that quarry to achieve that goal.
So I guess my concern with that statement was what part of that number 1 actually needs to be in here versus doesn't need to be in here?
It truly doesn't need to be there. You know, it's recommended approaches. There's nothing that really you as a commission can do with an existing use.
Well, and it's not an action item or a suggestion
No.
for us per se as a commission.
It's just a comment.
It's a comment, and I don't think that comment's supposed to be in there to that degree.
Well, I mean, that's you need to make that decision as a group.
I mean, what does everyone else think?
I don't think the comment should be in there. I think it's unneeded.
Can I ask, I agree, it doesn't seem like it serves a functional purpose. Obviously, this isn't an administrative correction to an error.
No, this is.
So this would require going through our full process to make any changes.
These are accepted comments in the
Yes.
document.
Okay,
You
just
wanna-
wanna make sure.
If you want to remove them, you're going to have to go through the process of deleting them.
Right. Well, if they're not appropriate to be in there, then they shouldn't be in there. That's, I guess, the point.
That's the point.
Why I wanted to spend some time looking at it. Because it's confusing. If the rest of the flow of the document is action items or suggestions for how the commission needs to act, that's what should be in the document. So I think that one needs to come out. Okay, and then the number 2 is PDD approach recommended for remaining technology zone and adjacent residential land to the north.
You can interpret that, I think, in 2 ways. It's either a statement or it can be an approach. Could be an action item.
But I guess who's making that recommendation?
Well, this is your document, so you are making that recommendation.
Which we already have the PDD going up there.
Yes, and I think what the statement is supposed to say is that that the goal would be to mirror the technology park with the goals of the PDD. I think in one fat form or another. In other words, the format of the PDD is to encompass the technology park.
So I think the issue has been that for the longest time, we didn't have anything, we had nothing happening in the technology park zone. It was undeveloped.
Yeah.
And then the concept started to become more popular of utilizing a PDD to be more creative in what could be useful to the town, useful to develop in that area versus it being dormant, just sitting there as unused technology park zone. But to create a cohesive environment to some degree so that it works, portions within it work together with other portions. That's the intent of, I think, our past discussions. which I think Glenn and Pete, you've been here through a lot of that, and correct me if I'm wrong. And so I think that the PDD approach is an option for up there. It isn't the say-all, be-all of what we have to do, what we need to do, what we should do. It's a consideration. And so I don't know if I like the word recommended. And I don't know if I'm
Well-
being too nitpicky. What do you think?
I don't think it's terrible the way it is. It doesn't say you have to use a PDD. It just gives them an option.
I always like the words may consider.
Okay. That's a
I
small
feel like that's a small change, but it's open-ended. This seems more firm.
I'm good with that.
Yeah.
What does everyone think?
Agree with the statement you made.
Yep.
I'm in agreement.
Yep.
So may consider PDD approach for remaining technology zone and adjacent residential land to the north instead of recommended. Okay. So then the question becomes, so these statements were on the new version of, oh gosh, this gets confusing. So they were on
They're on the current
the
plan.
current page 54 that is online, but we swapped that
We
out.
made those corrections already.
And that's okay. And so the question I had beyond that was, do we want those recommendations to stay on page 63? Or where are they best suited? So 54 is related to enhancing and guiding economic opportunities. And 63 is related to enhancing and guiding economic development versus residential development. I say, so that's residential development on 63. So that's, I guess, the question is, where do those seem like they need to be?
What's the correct photo currently? We don't have the updated one, right?
So,
If the photo's if the photo's the current 2019 one, we don't outline the PDD, so it should not be included. But if the photo's going to be from the January 2025, it should be included. If that makes sense.
well, I'm not even getting that far. I'm still talking about we're removing the one item, number 1, keeping number 2, which then that's gonna have to be renumbered to just number 1. But
Well,
does it
yeah.
belong, does the may consider PDD an approach for the remaining technology zone and adjacent residential land to the north? Should that be on page 54 or 63 is my question.
You break it up into two and put one on each one.
And that's probably the right approach, because your PDD has both residential
Components.
components
Okay.
and commercial components. It's a mixed type of use, so it starts to, you're gonna have to start overlapping in different sections.
Okay, so and that's what I was thinking as to why I raised the question, is because both components are in a PDD. And so I think it should be that item should be for recommended approach added on to page 54.
Okay.
Recommended or what you proposed?
What I proposed, no, I'm suggesting it versus the verbiage of so page 64 and 63.
54.
54 and 63, sorry. So then we can go to the map.
The map it's got different notations on it, and I don't know whether or not, the only thing that changed as a result of the PDD, which was the reason why this was really revised, was that it was to be shown, basically shown on the illustration.
Right, so should we take the old map that has, so should we take for sake of not being so confusing, because I feel like once we start changing these maps, people lose sight of what we're talking about. Granted, sometimes the highlighted area that's on the map is a different color and depicting something different from one page to another. However, the general map, if we're gonna start talking about the PDD on page 54, you can't have a different map on page 54 from page 63 if you're referencing same things. It's too confusing. So like if you look at the one that we're changing it to for page 54, it's a hashed line for the loop roadway system. And then it's got the reduced quarry industrial zone and then the large technology park zone. It's got all of that information on there. Shouldn't that map be this map that's on page 63 with anything relevant to what's the content of 63 overlaid onto that map? Does that make sense? Do you understand what I'm saying?
Are you trying to say that if we were to take the map that's on page 63 in the version 2019, draw on the new PDD area, and then paste both of those maps in section 9 and section 10? Is that where we're going? Or did I get something wrong?
So what's outlined on here in this map is totally different than what was on 63 previously.
Yep.
And so the loop road's the loop road unless the configuration of the loop road that it's hashed on here has changed. So if the loop road's still the loop road and it's hashed on here, why are we going to change that? It looks totally different on the page 63 from the original 63, which looks totally different than, which these two here are the same between 54 and 63 previously. Just the highlights of what's highlighted are different.
What, and I apologize because this, I'm only as familiar with this POCD as the last couple of months, but the loop roadway system, that's, the hash line that's labeled, what exactly is that?
It's the road throughout
That was
there.
a theoretical road that would support the whole quadrant.
Okay, the reason I ask is because it goes, if we don't have a reduced quarry industrial zone like that drawing, then the loop road as proposed goes through the quarry land if you were just to put it onto the other drawing. So I don't think you could just put in that loop road.
No, it borders it.
No, because it comes here, so it's
No,
here.
the sizing's different between the two.
The two maps are different.
Yeah, but that's the reduced, and then my point is, this is, you see.
But I don't think it should say reduced. This is what it is, existing quarry.
Yes, but so if you look at these if you look at these marks here, then this would come through here.
But I think in the 2019, this was a rough idea, and this seems like a more concise drawing.
No, I understand, but we can't just, we just can't drop this in here
Well, I don't think that we should
because.
drop that in there. I think
Okay.
we should keep this and take anything that's in here and put it here.
Yeah, but I just mean that loop road would have to, we can't just take what's there and put it there, presumably, because it would go through the quarry zone. We'd have to draw a different loop road through there.
So the
Is
question,
my point.
But the question is which loop road that's depicted on between the two maps is accurate.
Probably neither.
Well, I mean.
Well, you could look at
just
the
under-
highway. There are two different areas.
Yeah, but there's no loop road.
Well,
Just
yeah.
under-
So basically, right now, it's imaginary.
Yeah.
Just understand that you need a loop road for the whole area, and that the PDD will have a loop road within its own area.
Right.
The roads may coincide, but there's gotta be a continuous loop in the PDD area so that they have access to all the facilities that they're building. But then you have to have an overall loop road so that the whole quadrant is covered. How it overlaps or whether it overlaps is, that's your decision, whether you wanna be, have basically two loops that are connected at one point so that, you have the big loop, and then off the big loop, you have a smaller loop, and that's in the PDD, or whether you incorporate the PDD loop into a bigger loop.
Right.
If you follow what I'm trying to say.
I do, but the confusing piece is that it's depicted in one way on page, the old 63 versus the new 63. So why did we change the map?
That was a decision that either you made or the planner made for you.
I think the planner made it for us. I don't remember changing the,
Kind of agree too.
I don't remember
Well,
changing the confines of the map.
This is the opportunity to create your, whatever illustration you want for your plan.
Mr. Gossi, I'm sorry, Madam Chair.
Go for it. Will you put your mic on?
So, Mr. Bossi, does it even have to have a loop road depiction on it?
No, it doesn't, but in a sense, it's practical to have a loop road because you need to provide infrastructure to service that area. So you're trying to just give kind of a broad picture of, okay, you know, there is gonna be a road in here and it's gonna service everybody.
But can't we do that like a shaded region or something?
Well,
Instead
that's
of like a loop?
That's the hash, that's why the hashed one is in there.
I get that, but the hash and the photos are completely
I don't know, I guess
different.
the hash is better than the solid.
That's
line.
that's my point is I think we should revert to that other map. Why did we change it? Doesn't make any sense.
Yeah, 2019 makes sense. Well,
This one doesn't make sense.
I guess there's a road coming in. It's a new proposed.
Well, I wasn't part of the PDD, but I'm sure that in their concept drawings, they had a road network, and that's probably what was transposed onto this. My suggestion would be that we utilize the old illustration, and we superimpose the new PDD section on that old
Correct.
on that old map, and that'll cover everything. And all the other notations, we'll just take the. There's nothing on the new map that really matters, and we'll just leave the notations that are on the old map on the new illustration. So you have basically a third illustration, which will be a combination of the two that were previous to that.
Yeah, but I don't know. There's no key that decides anything on either of the maps. You do have a border that seems to be of a different color, but some of the stuff doesn't even point. The open spaces, key open space area seems to be pointing to what would appear on this map.
Well, you can, if in the actual color copy, everything is color coded.
Right, but is there a key to it that describes what those color codes are? Because I don't see a key on this paper that would tell me what this light gray area is.
It's where those boxes are that it's depicting it.
Yeah, usually there's notes on the side that color determines.
Well, then, just
the
out of
size
curiosity,
and-
what is this area
Yeah,
then?
yeah, you know.
Because if we go off of this gray border here, it says that's the key open space, but that points to a much
Well, I mean,
larger
if you
area that
want,
they clearly intend to
if your
develop.
new illustration wants a key, we'll add a key. If that's, you know, we can add a key.
No, I do understand that the boxes probably had color around them that matched with the border.
They do in the actual binder, which brings me to the question of, does everybody here not have a copy of the, in color and printed of the P O C D?
I don't.
And the regulations and the ordinances and everything else? Well, then,
I don't.
everybody needs a copy, because that's what we're referencing. So when new commissioners come on, they're supposed to get all the information. It's supposed to come from the town planner.
Which we don't have.
Right, but Kurt's been with us for a while.
Well, we can work on getting you the colored copy of the plan of
Because then they
development.
can't really tell what, unless I didn't bring mine, because there's so much stuff to bring here. I didn't bring my actual whole one, I just brought the photocopy pages, but the documents,
I mean, I can
less-
call it up on the screen if you wanted.
could
to
you
see
pull it up? That would be easier for them to see. I mean, the same thing goes for, you know, I guess my other question is, on page 54, item 3, and that's so different from that one. It says, consider reducing the quarry industrial zone to the area which has been quarried, except as may be needed for implementing an appropriate quarry closure plan. Like, who am I to tell a quarry that they're gonna close? And who's suggesting that?
Did we pay a professional to do all that work?
Well, yeah,
Am I
but then
correct?
it's like every single nuance of this thing, we have to do ourselves apparently, because,
If I can go back to something that was said, and I don't think I have significant concerns with it. Sort of an offhand remark, so bear with me, but there seemed to be a question of how we even got from this illustration in 2019 to the illustration that shows in 2025.
there was stuff that came before us.
No, yeah, I know, but someone said that we didn't approve it. We think the town planner changed it. I assume that's not a valid method by which the PDD can be changed.
It's
Is the
not
town
a
planner
valid-
just
Mr. Bossy,
making up
it's
his mind?
backwards. It's an Apple mouse. It's not a regular Microsoft mouse. So the click is reversed.
So no, there's a whole process of public hearing, public comment, has to
Yes.
go to, get a referral to, CROG before stuff gets approved.
Yes, and I have a general concept of that part of it, but it sounded about 2 minutes ago that we're saying at least several members of this commission don't think that happened because they don't.
Questioning the details that were brought before us that were discussed in what detail.
Okay,
And if things like, let's look at, I don't believe it was presented to the extent of, let's look at the map from 2019 and let's look at how the map has changed
Okay.
to where we're putting these additions in as of December 2024, which we haven't got to, which is related to what we're seeing in that map.
yeah,
And so I guess my memory from how many years I've been on this commission and the details of every single thing, I just can't fit it in my head.
sure.
I'm getting old, but I can't recall all of these details,
Okay.
which, if you listen to the tapes, if you read it take you days to go through all this.
Yeah. No, it just made me nervous to think that we might think the town planner changed something and didn't tell us.
No, like I said, was it the 2019 when we had it all for the 10-year plan, am I correct? So, the 2019,
Yeah, in 2019, it was the way it needed to be.
Yes.
But then it's these amendments, when the amendments were put in, things were adjusted. And the degree to which we discuss them and approve them versus the degree to which they are before us
So
Yeah.
is questioned.
this is the map on page 63 from the 19 version,
Right.
Yes.
okay?
there's your color.
There's your
Right,
color.
but the corner,
Thank you.
the top, the top northeast corner,
Yeah, it's sort
more of a
of
triangular shape. What is that designated as?
Where the green is?
Yeah.
It uses the same color code as key open space.
Here is open.
Then what's the yellow?
And
The
the yellow
yellow.
is very low density.
yeah, so you can see, it's tough to see it from here, but.
No, I
yellow-
see it.
Yeah. So,
But that's not the same on the new one.
no, that's not this one. That's the one to the left.
The green's protected areas, I'm assuming, right?
No.
It's just key open space areas.
Okay.
Yeah.
So, can you pull up the map? Oh, we're missing page 63, which is 54.
No, we corrected all that kind of stuff. This is the 19 version. If we go to the corrected 26 version, you'll see that page 63 is what is in front of you.
Right, but we can't, he's asking what's the color that's on the 2025 version of page 63. That's what he's trying to see the difference of. You see what I'm saying? Because it's the outline is depicting different things.
Page 63 on the 2026 version. is the same as the 2025. Nothing was changed on that.
It was though, if you look,
No, from 25 to 26, it wasn't.
oh, yes, but we're looking at 2019 to 2020,
Oh, I
the
thought you
revisions.
wanted to see the
So we
21.
want to see the color outlines on it, because it's what's that overlay piece on it to depict in the drawing. So we're trying to say, how'd we get from one map to the other map? And then what's highlighted on the one and what's highlighted on the other, and what are the differences and which is it?
So this map's got more detail. It shows those areas that are
Can you pull it
considered.
up more so we can see the whole map?
Yeah.
Oh, you're the best. Look at the color on that. Beautiful.
Oh, it jumped out.
Does this help you, Tom, so you can see it now? Because you haven't seen it looking like this.
No, I haven't, I've been on the website anyway and seen, I'm not sure which copy at this point, God bless the website.
There's several. Or several.
Well, it's less
But-
confusing than it was because it's all listed and you can see that progression.
Yeah.
Well, now everything's in purple now, which is the change that we had for the stuff that shouldn't have been in red.
But you can see that what they did was, instead of matching up with say areas, conservation areas they've identified as wetlands, they've kind of added detail but took detail away at the same time.
Oh, I feel that the newer map is the better map. It's more of an aerial map and it's more clearly defined, and obviously things would have changed from 19 to 2025. Things would have become more clear, so I believe that would be the proper map to be in place.
But the configuration of that loop road there is now solid versus the other one was hashed.
I mean, I suppose we could change it to solid.
And then the area on there for, what's the bottom box, existing?
Quarry.
But it is an existing quarry. I don't think
Right,
the old
I think
map
it
is
should
correct.
say existing quarry. I don't even like on page 54, item number 3, and I don't like the map, the drawing that's on there that is, considering the area for reduced quarry industrial zone. I don't like that. Because why am I telling the world that we're suggesting to reduction in a closure plan for a quarry?
Well, I mean,
I'm no
this
expert.
comment right here is really not practical. I mean, you can encourage it, but you can't force.
Correct. And so whose place is it to encourage it, and what's behind that?
Maybe the word, but if you're a CEO of a company, you come up with a succession plan. So asking the operator of a quarry, do you have any plans for the future when you stop using it? What will you do, or an idea?
Well, they'll put a plan in place and the time comes, but right now it's an existing quarry and it's
Well,
open.
I don't disagree. Encourage should come out, but there's no harm in asking.
So then why is it in there?
I don't know. I wasn't here.
And why is it on page 54? Consider reducing the quarry industrial zone to that area which has been quarried except as may be needed for implementing an appropriate quarry closure plan. So unless, the reason where that whole concept came up is because the activity based on 2019? No. Yes, 2019 was not as active. And so maybe there was a question of, was it going to be the activity increased to the extent that we see it today? And would it go the other way and would it close? Because we didn't have
Well, I
a
mean,
crystal
as a
ball.
commission, Tilcon routinely told you that it wasn't closed and they had no plans to close it. I mean, they told you that pretty much when I was actively involved in coming to planning and zoning meetings years ago, they specifically said it during their reviews that it was active and they had no plans to close it. However, you have to understand too, we hire an outsider, and quarrying is an industry that is not necessarily something that most communities desire. So you've got an inexperienced planner at the time, and you've got a consultant that's not necessarily connected to the town in any fashion, and It tries to make the best, understand the town as best they can, and then he's got his general experience out there in the world, the rest of the world. So in a comment like that, it doesn't seem unreasonable to me. It might have been that you were rushed when the group as a whole was going through these documents. I don't know, during 19, I wasn't involved in the plan of development in 19. but
And
I
that was
know-
before Mark came back,
and I
correct?
know that in 9, when I was involved in it, they throw a whole slew of information at you, and they'd be looking at you to make a decision almost the same night. And
Right.
they would, they would just keep throwing information night after night that you met.
That's what happened in 19 also, and I'm sure, the guy was a great guy, but he was a single planner by himself. I don't remember the name of him or the firm, but
Was
that's how it came.
With the
in.
planometrics, yeah.
I mean, there's nothing wrong with the comment, but the comment is in reality.
Correct, that's my point.
And you have to understand, even what they're proposing in this, say, low-density residential, is that really reality if the PDD comes to fruition? Or is this owner gonna say, wait a second, guys, you know what? It's a better use of the land to do something that's similar to the PDD.
I think the suggestion was for workforce housing in the area where it says the low residential density. And then the higher density was gonna be further, or maybe I had it reversed.
No,
I had it reversed.
Yeah, I think it was reversed, that they were gonna provide housing to create a campus environment for
Right.
workers, so that basically you stroll out of where you
But
live.
that's down, that was down lower on,
That's in this
yeah,
PDD area.
right there. But then there was gonna be more housing, but it was further back, but that was gonna be higher end housing.
Yeah, well, I mean, that might come to be, but as an owner of a property, at that particular time, if the PDD comes to fruition, wouldn't you think that the person's gonna look at it and go, if that was successful over here, how come, I probably can do something over here very similar and be more successful from a standpoint of dollars and cents. I mean, the PDD is gonna make more money than single family for the owner of the property.
Right.
So, I mean, you're balancing what it hasn't come to be yet, and what it would stand to be now. If that was to be built now, yes, it would have to be, low-density housing. There's very few infrastructure up there, and, you couldn't support high-density housing up there. But if the PDD comes forward, we're gonna have to bring infrastructure to support that. So now you're gonna have the opportunity to expand upon something that's already there. So you could go to a higher density use, whatever it may be, commercial, residential, whatever it happens to be, industrial. But it's likely not to be if the low-density housing if everything works out.
I mean, and this plan is suggestive anyway. It's not,
But-
there's nothing in
But from right now, you can leave it as high-density housing. When you do your plan of development, either in 29 or maybe even in 39, that whole concept might change. I mean, I don't think you really want to get into the nitty-gritty of rethinking sections 9 and 10 on your own. I think you're gonna want
No.
to wait until you have a consultant to assist you and provide you with the backup that goes with it, because as you recall, they do a lot of census data, and they collect a lot of data on a lot of factors, and then use that as to kind of plan out where the town's gonna be.
Right.
So I guess what we're trying to do is we're trying to have the same map in chapter 9 as in chapter 10, because they're really talking about, there's commonality between them.
So you're saying page 54 and 63?
Yes, and the big question is what illustration do you want, or what information you want on the illustration? Do you want a map that's more
So-
similar to 19, or more similar to what's in the 25 or 26 edition?
Well, there's different content in the colors on that map there's more of a depiction, more detail than what's on the page 54 map.
Well, there's different detail too.
Right.
different opinions too.
Well, and the different detail that's on there has to go on 63, because it's relevant to the content on 63. But I don't like the fact that the loop road is changed. And I don't like the change in the size between the highlighted area that's suggesting the area for reduced quarry industrial zone and the existing. I don't like the difference in that because it's very confusing.
So are you supportive of the existing or the active quarry?
I'm supportive of the newer map. And the loop road isn't specific to the PDD. It's not specific to the undeveloped areas. So that loop road, whether it changed from a dash to a solid line, is a loop road for the PDD area.
Right.
These other areas, these big chunks of areas are not developed, they're not labeled as PDD. These are more of suggestions of very low residential density. As Mr. Bossy stated, they could change over time.
Yeah, but how accurate are they?
Yeah, but how accurate are these?
Exactly, that's what I mean.
It's all opinion. It
So
changes
it's
every-
merely just
Yeah.
pick one. I personally like the aerial view. If we want to change the dark line of the loop road that's within inside the PD
To
to
the
dash,
hashed.
I don't care.
That's my.
But
The
then
hash,
what do we
the
do-
hash probably makes sense because it doesn't, it's not like clearly defined. This
Right.
makes it appear that it's,
Set in stone.
because the line coming in from New Britain is a
Right.
solid black line on both drawings.
Right.
And that is an existing road.
So then the question becomes the area that is depicting, because this was a big issue that the public had raised, is it the confines on that map of the existing quarry is depicted very differently than the area of suggested reduced quarry on page 54. So then what do we do about that?
I don't know, but again, the 2025 map,
Well,
I
the
think
area-
better depicts what it is and who said it was getting reduced.
Yeah.
Well, that's another piece of this.
Exactly. But the aerial photo shows pretty well exactly the way it should be. Well, this one is probably what? You know?
So then should this map be updated with, so that
I
they're
think we
both the
should,
same
like
map?
Mr. Bossy said, get rid of this, take this. If there's anything in here that we like that should go here, move that here. These two maps are the same.
And then can we get rid of, so can we, if we're making changes to these pages that have to go to CROG and have to go to public hearing anyway, we get rid of number 3 on page 54?
I mean, we can, and I was hoping that we would concentrate on chapter 10 this meeting, and we can go into chapter 9 next meeting.
Okay,
I was
so
hoping,
I thought we were gonna kill all the birds with one stone tonight.
Well, we could if you
Although
like.
I love my birds and I feed them multiple times a day. I don't
Well,
care
we
about
could,
it.
but I was trying to,
John, I can't keep dragging this on, my friend. I'm losing sleep.
okay, well, I mean,
I'm trying to move it along.
well, hopefully next meeting will be a lot shorter because we've gotten rid of one of the main items on the agenda, so at least I think we got rid of it.
You notice I dyed my hair
Yes,
this
I
time.
saw
I
that.
think I need to have it on like my stipend or something for putting up with these meetings.
I mean, I
Oh
was
my
thinking we would be cutting this off in like 5 minutes anyways.
I'm past my bedtime.
We scheduled, I thought this was gonna be a 45-minute discussion. We accomplish what we can in 45 minutes and then we move on.
All right, so then, so the
Huh?
map is not, so we haven't decided definitively on, well, what else do we have to do? Just the 2 comments, the
Well,
amendment?
we have the 2 amendments on the left-hand side. We already spoke to them. There's two additions on the right-hand side.
People need to employ the use of sanitary cisterns with a timed release to coincide with off-peak usage, okay. And consider a mixed-use approach to encourage a work
And that,
line.
those are specific to the PDD
environment
that you,
boundary development
that
may
you approved, so.
Consist of high-density residential, commercial, restaurant with due consideration to separation required between such uses and the need to preserve open space. So we're talking about So we're on our map, we're depicting very low residential density, open space. Yet we're talking about the comment of high-density residential, so which is it?
Well,
High density within the proposed PDD.
the two comments on the right-hand side or right-hand part of the page, they are specific to your approval of the PDD.
Right.
Yeah, I think they're fine.
The question is are the words what you want it to say, or
Or do they
you
only
wanna-
need to be on that page, but they're still talking about residential, but residential is also relevant to page 54, so do they need to be on just page 63, or 63 and 54? Where do they belong?
Well, we know that the first comment, the top comment, that only belongs on page 63.
Okay.
We know that, because
Yep.
that's a utility issue. Whether or not the second comment is on page 63 and 54, I mean, since we're moving the illustration and moving the comments so that they're
The same.
they're the same, then I would suggest that something similar to this needs to be put on page 54.
Copy that comment, removing all the extras except for the high-density residential, and on the 63, yeah, all of it can stay there.
Well, I think the comment for the amendment on the bottom, the second one on the bottom, I think needs to stay on 63, but my feeling was that it also needed to be added to 54.
But if 54 is more specifically residential, and I'm not claiming that I know that exactly, I would default to you, because I don't have 54 in front of me. But yes, you would copy the second December 2024 amendment.
54 is related to enhancing and guiding economic opportunities. So that's everything.
Okay, sorry. So I thought it was more specifically, 54 was more specifically
No,
for
neither
residential.
one of them is.
So then put them on both.
Okay.
And I'm just curious, why number 3?
Number 3 on page 54, because it says, consider reducing the quarry industrial zone to that area,
Okay,
which
sorry.
is,
I'm only looking at 63 and
Quarry.
number 3, and it seems to make sense to have a road.
yeah, no. And so I don't like that on there.
Can I see that? Sorry.
So, I mean, from my perspective, on page 63, we're gonna we're gonna go to public hearing on eliminating.
Number 1,
Number 1, modifying number 2,
and changing
and-
number 2 to number 1.
yes, and also adding, number 2 to page 54 someplace.
Correct.
The new number 1.
Yeah,
Yeah.
okay, well, yeah, all right. And then, the illustration,
Yep.
I don't know exactly what we're gonna do there. Are we gonna use the new map or the old map and modify whatever we wanna add?
The new map,
We want
because
the new map.
we want the new map, and then we just
What?
have to,
We wanna clarify the loop road to be dashed so that
Yeah.
it's consistent with the schematics of the whole map or the illustration.
yep.
And do we wanna add any comments that are from the old map onto the new map?
They're honestly the same.
Okay. All right,
Just change the road to a dash.
okay.
Well, no, because the comments are totally different.
No, they're the same.
No, they're not.
Loop roadway system,
Very low residential with 50%.
possible loop road. I think possible is better than loop.
Are you looking at page 54 and what's on the
I don't
map
have
on
that.
54? That's what I'm
No, we're-
saying.
No, we're looking at the maps on 63, the old and new.
Yeah.
That's what we're all looking at.
Just those two that we're all looking at.
You're looking at these two.
Yeah.
I don't know what theirs is from.
It's the same as page 54.
Well, if this map's the same as page 54, I feel they're all more or less the same. Key open space areas, key open space. So they remove the word areas. Protected ridgeline is not on the old map. It's fine that it's there, very low residential density, 50% open space, which is exactly what the other one says. I don't like, and I thought we all said we didn't like the reduced quarry industrial zone, the existing quarrying zone, possible loop road. The old map doesn't say a loop road, so
I'm still stuck on reduced quarry industrial zone. Do we know in 2019 if the quarry industrial zone was reduced in size in some way?
No, it was not reduced in size. It was a goal or an aspiration to consolidate and constrain, because it's, as you saw tonight, it's in conflict with a lot of the things around
Yeah,
it.
yeah, but
That-
that's
that-
not something, it's not something that actually happened.
No.
It was just a
Yes.
it was a.
Yeah, all this is opinionated.
Yes.
Suggestive.
I mean, we need to realize that when you have a zone that's, I guess, very different than another zone, usually there's a transition. You go from I'm gonna use the wrong terms, but you're gonna go from a use that's less desirable to one that's more desirable to the most desirable.
Yeah.
And
It's a transition zone usually.
in the sense of people that live in town, residential, single family is the most desirable, and then it goes to multifamily, and then you go to commercial, and then you go to industrial, and then that's usually the pyramid kind of thing.
So out of curiosity, are we, because I attend a lot of town council meetings, but do we, with all of this, apparently in the past, we have sent over our plans for changes to the POCD?
Yeah, it still has to go the same exact routine.
But
It has to go to the town council, it has to get their blessing, all of those steps, if we do any of these changes.
Is all going,
The
okay.
whole thing has to go the
Yep.
whole process. We're
Okay.
not skipping any steps, it's
Perfect.
formal.
Okay, thank you.
It's the same way every single time. All right,
So what I'll do is I'll prepare, hopefully for the next meeting, I'll prepare a revised page 63. We'll revisit page 54 and whatever section in page 54 at the next meeting. Hopefully it'll be a short discussion and we can move on, and then I'll
Well, we already
revise that.
talked about 54,
And I'll revise
except
that
for
one.
number 3.
I'll revise that one, and then from there, we can begin the process of notifying whoever we have to notify that we have an intent to change the plan of development, and we go from there.
Madam Chair.
Yeah. Put your mic on.
So, Mr. Bossy, can you do the changes we talked about, not actually into the document, an example of the changes we talked about?
Yeah, like
On
it's a-
54 and 63, coming to the next meeting.
So we can
each
see
get a
it.
copy and go, yep, we
This
like
is
it.
what we
Then
want.
we can kick it over.
That's my intent,
Yeah.
to revise page 63 and 54, and give you an opportunity to say, oh, no, you did it, you did this is not what we really want, we want this.
And
And
fix
then
it.
I will fix it again and come back to you, and then when you gives me the thumbs up, we'll start the process
Because it's
of,
gonna have to go to public hearing, there's a whole,
and we'll
To make
review
a
that.
permanent change,
Yeah, to
correct.
make the
Correct.
permanent changes,
Thank you.
okay?
thank you, John.
Okay, can we go home now?
All right, so,
It's my bedtime.
anybody have anything else for John? No? Would someone like to make a motion to adjourn?
Madam Chair, I'd like to make a motion to adjourn.
Okay, second.
Third.
All those in favor?
Aye.
Any opposed, any abstentions? Motion carries.